Okay. Well, thank you everybody for being here and being part of the Veterans Business Outreach Center. This is our first event of the week as we celebrate National Veterans Small Business Week. And this presentation is being recorded so that we can share it on our website and our social media pages. So if everyone would just please mute your speakers so that we can hear the information, that would be appreciated. The Veterans Business Outreach Center is funded in part through a cooperative agreement with U.S. Small Business Administration. As such, the opinions, conclusions, recommendations are not necessarily those of the SBAs, but they are of the authors. We're pleased to bring you this presentation of what business owners need to know about trademarks. Our speaker today is Jimmy McNamara. He's an experienced attorney and founder of TrademarkEd, which provides trademark education to entrepreneurs. He's also experienced in the U.S. Trademark Office as a trademark examining attorney and also an attorney with the U.S. Securities and Exchange Commission. As an entrepreneur himself, he's going to share his expertise to help us know some important points about this topic. He'll give some examples to help you make good decisions along the entrepreneurship journey related to trademarks. And we'll save some time at the end of the presentation for your questions and any comments you might have. So thank you so much, Jimmy. Welcome, and go ahead and kick us off here.
All right, let me share my screen. And all right, everyone can see my screen okay? Well, thank you all so much for coming here today, and thank you for that introduction. To give you a little bit of a background on myself before we kind of delve into trademarks and branding. Like was mentioned, I'm an intellectual property attorney that focuses on trademarks and branding. And I worked for several years at the Patent and Trademark Office, specializing in trademark applications and trademark prosecution, which is the process of applying for a federal trademark. And I graduated from Georgetown Law in 2016. So to give you an idea of why I became interested in trademarks and why I think it's so important for small business owners was really based on a personal experience that I had years ago when I was still a student. I had a different startup at that point that I was working on. And it was this really strange situation where I realized that the huge company Glassdoor was actually infringing on my trademark. I'd used it before them, and I realized that they hadn't even registered for it. And it became this kind of interesting David and Goliath situation of going up against a corporation that has so much resources, so many attorneys, and trying to tell them, about the trademark rights that I had because I had applied for a trademark. And what I learned from that experience, and I eventually did get a settlement from Glassdoor, is that trademarks are the great equalizer, because Glassdoor obviously had way more resources and they could certainly delay or make things challenging for me. But ultimately, they had to agree to a settlement because I had this federal trademark. So it made me realize, I think, that how valuable trademarks really are. And then to give you another example, they're a great equalizer against bullies in general. A lot of times with small business owners, you might be on the receiving end of a cease and desist from this established corporation, or people with greater resources can bully even if they don't actually have the rights to a federal trademark. So I use this as an example of when President Obama was very much a trademark bully to an entrepreneur, a solopreneur. This woman had registered for the trademark High Ground Enterprises. And a year later, Obama had this deal with Netflix and he applied and got rejected for the trademark Higher Ground Productions because the Trademark Office found they were too similar. And what happened then was Obama, and Michelle Obama also was a former trademarks attorney, is they started to look at every type of technicality to try to invalidate this prior owner's trademark application. And even with these expensive attorneys, she did everything right. They couldn't invalidate it. We don't know how much they settled for. That's private. But ultimately, she stood her ground and, we can imagine did somewhat okay in that transaction. So today we're going to be focusing on a few key issues. We're going to be talking about what is a trademark. We're going to do an overview of IP in general. What's a trademark? What's a copyright? What's a patent? What's the difference between those? we're going to talk about why do you even care about a trademark and what are the benefits? Why do I even think I need one? And then we're going to do one kind of practical exercise of teaching you how do you look on the federal database to see if someone has already registered for your trademark. So how can you see if you might be infringing on someone else and your likelihood of registration chances if you did submit a trademark application. So we'll start with the basics, the 101 of what is a trademark. So trademarks are words, logos.
Excuse me, Jimmy, we're not seeing a presentation.
Oh, whoops.
Do you want to share that? I mean, your presentation is great just with your
no,
words,
I thought I was like in a
something.
small bubble. Not sure. So
let me see if I can do something here.
my apologies.
That's okay. At least I'm not seeing it. If anyone else says, you could let me know. There should be, oh, it's just me then. I apologize. Other people are seeing it. I'll make some adjustments.
Perfect. All right.
Thank you. Thank you to the chatters.
Oh, good. Thank you. So a trademark is just a word, logo, design that helps consumers identify the source of a product or service. So to give you some examples, if we look at this page, hopefully everyone can see, even though these are just design elements, we all recognize those brands. We see Ralph Lauren, we see McDonald's, we see the Apple logo, and then Nike. So you can understand from a large corporation's perspective how valuable that intangible IP is for their brands and how much they need to enforce that as well. And let's see, is this... Okay, so when we think about trademarks, the overarching real need is to prevent brand confusion. And to give you an idea, I think this says McDonald's, their intangible brand value is worth $155 billion. And so we're thinking of it from a huge corporate perspective, but you have to be just as smart with a small business of making sure if you really do care about a slogan or a logo or a brand name, that you're establishing a foundation to protect that brand. So to give you an example of why do we care, if you think of this example, there was a company at one point that came in and did a very small misspelling of McDonald's with an A. And you can see why that would confuse consumers. They're kind of infringing on that goodwill that people know McDonald's is a reliable brand. And if some other guy that's not affiliated with McDonald's starts to open up a burger shop, you can see how that wouldn't be fair. So really, when we're talking about trademarks, and we'll delve a little bit more into the specifics, think about your brand. It's really about protecting your brand. So when we think about all of intellectual property, we also have to consider copyrights and patents. And when we think about patents, we're just thinking about inventions. And there are two main types. With the utility patent, we're protecting how something actually works. Whereas with design patents, we're really protecting how something looks. So to give an example of that, we have a utility patent for the light bulb. That went into how did he actually protect the process and the function of how that actually worked through a patent. Whereas with the design patent, it's not about the functionality. It's purely the design, how it looks. And Apple has a lot of patents as well, of even just for their iPhone, the way it's designed in the grooves is a patent that they can protect other companies from having that similar design. Whereas with copyrights, we think about it as protecting original works of authorship in fixed form. So we can't just copyright an idea that we had in our head. We have to put that idea down to paper. And one of the good things is that something is automatically copyrighted as soon as you put it down on a piece of paper. But by registering for a copyright, you do have certain benefits, like being able to sue for damages in certain circumstances. So with copyrights, you're not thinking about a brand, but you're just thinking about, these creative expressions, whether it's poetry, a book, or a movie, or a song, or even now increasingly that counts as computer software. And of course, we think of Disney as very big in this area for copyright law. So trademarks, copyrights, and patents are everywhere. We probably see thousands of trademarks on a day-to-day basis. We're just so immune to all these brands around us. But if you can think of the example like McDonald's, you see the M or the name McDonald's, you know that's a trademark. A copyright might be that they have these Disney products inside that they sell with the Happy Meal. A patent could be that perhaps they're protecting some type of technology and how they create, French fries, something specific to them. So brands have to consider all of these, but for the purposes of our conversation, we're going to be focusing solely on trademarks. So do I need a trademark? And this is a really important, it's a legal question, but it's also a business question as well. It's a personal question. How much do you want to invest in that logo? How much money does someone have? You don't want to be filing a trademark application for every logo that comes to your mind. So you definitely do not need a trademark, but we're going to talk about what do you lose as protections by not registering for a trademark. So to give you an example, let's say I have this trademark Barber Boss, and I'm only in the area of Baltimore, and I open up a shop there. Even if I don't apply for a federal trademark or I never get a federal trademark, I still have legal rights when it comes to that area of Baltimore. We call that common law rights. So even though I never applied for a federal trademark, I can enforce it in that small area. But the difficulty comes with when you don't register for a trademark, you don't have broad protection. So when you do receive a federal trademark, you have protection in all 50 states, even if you're not in that state. So if Barber Boss wanted to open up a new shop, whether it's in DC or Los Angeles, by getting a federal trademark, they know that they can expand without a headache. Whereas if they never registered for a trademark, and let's say they did want to become this national brand and open up a new branch in DC, well, they might run into an issue with someone who has that federal trademark or has been using that trademark prior to them in that new area. So you will have some protections by just using a trademark in business, but you're losing kind of that peace of mind of this broad protection of all of the 50 states. Another distinction is you can only sue for trademark infringement and get damages when you have a registered trademark. So if I hadn't registered, well, I didn't end up in court with Glassdoor, but I couldn't even threaten that potential if I didn't have a federally registered trademark. So if you're arguing with this company over rights, you're coming from a much weaker position if you never registered for a federal trademark. The other issue is you could be sued for trademark infringement. I think by registering for a trademark, it gives you that peace of mind of, I have this protection. And you're not kind of waiting for this situation, even when it's not even intentional on your part, that others can then accuse you of potentially being an infringer. And then a big part is a lot of businesses, and I think it kind of shows a sense of legitimacy a lot of times, is the ability to use that restricted R symbol, which denotes federal protection across all 50 states. And actually, if you use it and if you use that symbol and you don't actually have a federally registered trademark, you can get in trouble. So it's really reserved only for federally registered trademarks. So the issue then is, I want to apply for a trademark. Let's say you are, interested in applying for a trademark, but kind of similar to the Obama situation, you want to figure out, well, is there already registered trademarks on the database that are going to be confusingly similar to my trademark? So this is a legal determination, but we have to think about it from kind of a common sense perspective, that when we're trying to see if another trademark is too similar to ours, such that the PTO is going to reject ours as being too similar, we want to ask ourselves, just think of it as a basic consumer. Would you get confused about the source of the product or service if you saw the trademark you want versus, in the same store as the trademark that's already registered. So to give you an example, the McDonald's example from before, the McDonald's versus McDonald's with an additional A, phonetically, they're the same. Does the A really change the meaning? No. And even if you had McDonald's is known for their yellow M, if you had a blue one, you're still going to think about McDonald's. So I think for most consumers, you're kind of safe saying, yeah, I think I'd get confused by that. So this is actually legally called Section 2D likelihood of confusion. But all it is that test of asking yourself as a consumer, as the average consumer, would you get confused? So the Patent and Trademark Office, when you do apply for a trademark, they're going to search their database to see if there are confusingly similar trademarks. And I'm going to show you in a little bit how you can do that as well. So the first process of thinking about, are these trademarks too similar or not, is we have to consider the trademarks themselves. So before we even think about what you're selling, what your goods are, what your services are, we want to just focus on the trademark or the logo. So there are 3 examples that you can say are pretty similar. So if you have an identical trademark, let's say I have the trademark McNamara that I want to apply for, but there's already a registered trademark of McNamara. That's going to be hard for me to argue that they're not similar. I mean, they're identical in that case. So most likely that's going to be problematic. Then we think of phonetically equivalent trademarks. We think of the McDonald's example versus McDonald's. They sound so similar. And when we think about trademarks, a lot of times you're not actually seeing them in written form. You're speaking about them. You're hearing someone talk about a brand. So in those cases, you're not even thinking about the visual distinction. So they're equivalent when you hear them. So that's going to be problematic too, if we see something that's phonetically equivalent. Or we think of trademarks that have the same meaning. So if we have the trademark 2 cats and the trademark dos gatos, they're not identical. They don't sound alike at all. But most people are going to see that trademark and immediately think of the same thing, of 2 cats. So we have to think also about the meaning when it's clear, is someone going to get confused because of the meanings are so similar? So just as a recap, we first want to look at the trademarks. Are they identical? Are they phonetically equivalent? Or is there something about them that it's really kind of conveying this same meaning? And then the second part of this inquiry is, what are the goods and services? So you have to think about, what are the goods and services of my trademark that I want to register? And what are the goods and services of the trademark, or in this case, the registrant's trademark that's already registered? So we've already compared the marks, or the trademarks themselves, and now we're going to look at the goods and services. So we're going to go through 2 examples. The trademarks cat shenanigans versus kitty shenanigans. So let's say I have the trademark cat shenanigans that I want to apply for, but I see on the PTO's database that kitty shenanigans is already registered. Well, if we're just looking at the trademarks themselves, I would say that those are pretty similar. We have the word shenanigans that's pretty dominant. And then the really only difference is cat and kitty. But like the example of dos gatos, it's still conveying the same message. So even though there's a little bit of a difference, I would say that just looking at the trademarks themselves, this could be problematic. So we did the first part of the inquiry, and now we're going to look at the goods and services associated. So let's say the trademark is cat shenanigans for t-shirts that I want to register, and I see kitty shenanigans for website development is already registered. I think the trademarks themselves are pretty similar, but if we look at the goods and services, would a consumer actually get confused? And I think here the answer is no. If I'm going to a store and I want to buy t-shirts, I'm not thinking about website development services. Or if I'm doing a Google search for t-shirts, most likely no type of website development, prompt or result is going to come up. They're so different. So we have to really think about the tests as being 2 parts. So even though cat shenanigans and kitty shenanigans, we can all agree is pretty similar, if the goods are that different or the services, it's not going to be a confusingly similar trademark. So in that case, I would probably be allowed to register for cat shenanigans for t-shirts, because kitty shenanigans for website development is just such different services that no consumer is really going to get confused by that. But now let's use another example. So the same trademarks, cat shenanigans and kitty shenanigans, and one is for t-shirts and one is for watches. Now we probably have a problem. If I'm shopping for clothes in general, that's very related. You know, you might buy shirts and you might buy a watch in the same store. But one way to really think about it is to do a Google search. So if I did a Google search for t-shirts and I came up to a Ralph Lauren t-shirt or Ralph Lauren website, the question is, do you see them also selling watches? And in this case, it's pretty clear that they are. You'll see, you know, watches prominently sold by the same brand. So it's harder to say that a consumer wouldn't get confused because the goods are so similar in this case. So now you have similar trademarks, kitty shenanigans, cat shenanigans, and the goods are similar. So in this case, it is going to be problematic that that mark is too similar to then, you know, register your trademark because it's already registered before you. We'll give a real life example. This happened. The company Supermax is a burger store in Ireland, and they were sued by McDonald's as being too similar. And their argument was the Max part, that, you know, McDonald's, that Mac is really pretty known. And they're, by calling themselves Supermax, McDonald's argument was that it's too similar, that it's going to confuse customers, that people going into Supermax are going to still think about McDonald's. And then if we look at the goods themselves, well, those are pretty identical. We're looking at similar fast food. And the winner of that was ultimately Supermax. The court found that these marks weren't sufficiently similar. And I think it probably came more to the analysis of the trademarks of Supermax versus McDonald's. But it shows that it's not, even though it's a legal determination, I want you to think of it more as kind of a common sense. Because when it comes down to it, the arguments that you make are often, you know, are the goods similar enough? Do you get the same meaning from these trademarks? It's not some, you know, high concept. It's really just thinking about it as a customer. What would you think? What would you think if you're going into a store? Would you be confused? So that's the best way to approach that particular issue. So now we're going to learn, how do I actually search for other trademarks on the federal database? Let's say I definitely want to apply for a trademark, but I want to learn, you know, is my trademark already taken? So for that, and we can send the link out later, but basically on the PTO website, this is all public information, which is great. You can search the data. Everyone can see the screen, I hope. So we can search for trademarks that are either pending or that have already registered. So the best way to look at it is to let's do a basic word search. And with this, you're going to type in, you know, the name of your trademark that you want to register. So whether that could be, you know, just do it for the Nike slogan, or in my case, I could do TrademarkEd. Let's see what comes up there. And then this is the one you want to choose, is a combined word mark, because we're looking for trademarks. And then all you do is submit the query. And it's going to come, everything that has the words trademarked in it, in the trademark name, is going to come out as a result. But now we have to look at, are these results actually confusingly similar? So just like that examples that we gave of going through those two steps of, are the marks similar? Are the goods and services similar? You would do that with your results. So let's say I looked at, before we begin, we want to check whether a trademark is live or dead. So if it's live, we have to consider it, because that could be problematic and it's either pending or it's registered. But the good news is, always look to see, is it dead? Because if it's dead, that means something happened with the trademark where they either abandoned it or it didn't register. or maybe they had it for a bunch of years, but they didn't continue with it. Those we don't even have to consider. That's not going to be an issue when it gets submitted to the PTO. So in this analysis, we're kind of lucky because three out of the 7 are already dead. So before you even look at any trademarks, the first step is really to think which are the live ones, which are the dead ones. So the first one is my trademark that I just registered for. And if we look at the next trademark, so it'll say the name of the trademark up here. In this case, it's called "You Should Have Trademarked That." Okay, so we know what the name of the trademark is. But now remember, the importance of the second step is comparing the goods and services. So let's say my company is more about trademark education. Those are my services. If I look at their goods and services, which is right down here, that's how I know how I can compare the goods and services. So in this case, it says all-purpose carrying bags, and then down here it says clothing, namely tops, bottoms. I'm fairly confident that providing educational services is not going to be too similar to buying clothes. But if, let's say, the services were a little bit different, let's say it did involve education in some capacity or was for a university or educational outreach, then it's probably going to be more problematic. But then also, if we look at the wording of the trademark itself, you should have trademarked that versus TrademarkEd. Those aren't really similar. One is a very specific meaning of, hey, you need to trademark that, used for clothing. And the other one kind of creates this meaning of education. So I would argue that those aren't similar either way. The marks aren't that similar and the goods and services aren't that similar. So even if they had registered before me and I saw that come up and it's still alive, that's not going to prevent me from applying for a trademark. I would not be worried about this result. But you can see the process of what you go through of, again, it's just looking at the trademarks themselves, looking at the goods and services, and asking yourself from a basic customer's perspective, would I get confused if I saw these two trademarks, and thinking about the goods and services in question as well. So I would just go down this list, and the next one is 3D trademark bottle. Well, that's definitely not similar when I look at TrademarkEd versus a trademark bottle. So I wouldn't worry about that. And even if the goods were similar, the marks are so dissimilar that I wouldn't be concerned, because again, we want to know that the marks themselves are similar and the goods and services are similar. You need both of those prongs. So just as a quick recap with this, you go to the Patent and Trademark Office website. And for here, you'll be a new user. You don't have to register or anything. And in the search term, you want to search for your actual trademark. And it's going to come up sometimes with phonetically equivalent marks as well, which is good. You want to consider that. But you're going to try whatever trademark you can think of, well, let me do McDonald's. And you want the combined mark. We're going to search. And as you can see, there's a lot more records. And McDonald's has a lot of trademarks themselves. So this one would take a lot longer. But again, we wouldn't consider any of the ones that are dead. And when we look at it, we want to consider the mark itself, which is, in this case, is another, I guess McDonald's is registering for clothing, it looks like. So you want to just consider the mark, look at their goods and services, and just ask yourself, would I be confused? That's all the Patent and Trademark Office is also going to do on their end. So I wanted to share also with you a free resource. This is completely free for anyone attending today or anyone looking at this video. And it's made really for people that are curious about trademarks, but that want to register probably on their own. So one of the issues with the trademark is they can get kind of expensive once you do have to hire an attorney. Another issue is a lot of times you get these office actions after you apply, where they're asking you to kind of fix a few issues. And a lot of times people think, okay, I need to hire an attorney now. You really don't. You just need to, learn the basics. And I'll show you that now. So this is the website, mytrademarked.com. And we'll have a login so that you can just go in directly for free. You can bypass the payment. Generally, it's $25 a month. But for this, it's free forever as well. There's no time frame for this, but you would log in, and basically there are 3 components if you are interested in protecting your brand. And the 101 is really about the basics. You're not actually applying for a trademark yet, but you want to learn more about it. So maybe you have additional questions like, when do I use that TM symbol that you see versus the R symbol versus the SM symbol? How do I search for federal trademarks? So there's like a 12-minute video on that. I briefly showed you here, but it goes into more depth. So let's say I wanted to do a federal direct hit trademark search. It's just a good reminder.
Services. So let's use an example
Of everything that we talked about today. So in a more clear way, these videos will really convey and hopefully answer those kind of 101 type questions that you have before you even apply for a trademark. And then the 102 is really about applying for a trademark, but completely on your own. So one of the frustrating parts of working at the Patent and Trademark Office is there were so many preventable issues or mistakes that because I reviewed so many, you would tend to see the same type of mistakes over and over. So this was really crafted to avoid a lot of those headaches. But it's 8 steps and it just walks you through the entire application. So everything from how do I create an account? How do I pick goods and services? How do I upload my trademark? How do I provide proof? So for instance, if you're using your trademark in business, the PTO wants proof of that, and they call that a specimen. So I could just watch that video here.
clearly shows the ability for consumers to.
And she'll walk you through all those steps. And then one thing I'll to kind of close with is, like I mentioned, most people do end up getting an office action that's super common. And it just means the PTO, they might have a rejection, or more likely than not, they're seeking some type of clarification. So it could be minor, like they're a little bit confused about your address. It could be they're not completely sure what your goods and services are, so they might be asking you for more specificity. Or maybe the proof, we talked about the specimen that you need to submit. Maybe there was some issue with the specimen that they didn't think it worked. So they'll send you this office action listing all the issues. So maybe you have 3 issues to overcome. And that, unfortunately, like I briefly mentioned before, is where a lot of applications abandon. A lot of people get overwhelmed because they see this office action. There's a strict deadline. It used to be 6 months. Now it's actually going to be 3 months that you have to respond by. So a lot of people procrastinate it. And the legal jargon does look kind of intimidating when you are reading it. So really the 103 is empowering you to respond to this office action totally on your own. So everything from, how do I actually electronically respond, like walking you through the PTO website, to whatever issue your application has, there'll be a video guiding you on how to overcome it. So let's say you got this office action that said, your specimen is not acceptable. The proof that you gave isn't going to work for us. That's okay. It just means you'll have to submit a new one. You get 2 chances to do this, and oftentimes you have many more chances as well. So you would just find the videos that are relevant to your office action. So let's say you have an unacceptable specimen.
I would need to provide
you can just watch this 5-minute video and learn how to overcome that one particular refusal. So the idea here, even though there are a lot of videos here and it can kind of look overwhelming, because there's, I think, 35 videos here. In reality, if you do get an office action, you're only going to be looking at maybe 2 or 3 of these videos, whatever's relevant to your actual office action. And most people, they get this non-final office action and you have a chance to correct it. And if there's still an issue, they'll send a final office action and you have another opportunity to fix it. And then sometimes there are ways to get additional opportunities to try to fix it as well. And the PTO does try to work with you as well particularly with more of these requirements that you can overcome. You just need to provide more, clarity. So again, just to recap on that, really the platform, it's totally free. We'll have a link that can provide free access, or you can also email support@mytrademarked.com. So support@mytrademarked.com, and we can provide you with a link to bypass payment for veterans. So again, this is just a 3-step process. A lot of people only use the 101 when they're just curious to learn a little bit more about trademarks, a little bit more about, what the TM symbol is, what's the difference between a trademark and a service mark, just some of these questions that people have, that the videos, they tend to be 3 or 4 minutes long. They're not too long. And then 102 is about how do I actually apply? It walks you through each step. So hopefully if you were going to apply on your own, it would take like 45 minutes to an hour. And then again, 103 is when you get this office action. So you wouldn't be looking at this for a while. One thing to keep in mind is that the Patent and Trademark Office is experiencing a lot of delays with the trademark. So to give you context, when I was working there, if someone applied for a trademark, within 3 months, we were generally reviewing that trademark application and making a decision. Whereas now, because with the pandemic, it actually, the opposite effect happened, where so many more small business owners applied for trademarks, that 3-month waiting period is now approximately a year. So that's one thing to keep in mind in terms of when you are applying for a trademark, that it's not an efficient process even after you submitted your application. So even if you did that step and you went through 102, you're not going to hear for a while. So that's one thing I do tell business owners, if they are really serious about their brand and protecting it, is to get that application in. And another aspect that we didn't get to today, but you can actually apply for a trademark even if you're not yet using that trademark in business. So let's say you are working on kind of a prototype for a company, or you're working in so many ways towards your idea, but that idea hasn't actually gone out into the world yet. You're not making money yet. But maybe you like that trademark so much that you want to protect it even before, you open your first store or go to that first public market. In that case, the videos will walk you through it in 102, but you can still apply for that trademark, even though it's not in business yet. And the only difference is, and the PTO will charge you with $100 for it, but basically, whenever you do start to use it in business, you'll have to file this form with them of showing proof. That's the specimen we talked about. And then they'll count it as if it was the date of the application that you initially applied. So that's something I tell people to keep in mind when they really love, a trademark, but they think, well, I haven't used it in business yet, so I don't need to register it. That's not true. You can, as long as you have a genuine interest, a good faith belief that you're going to use that trademark, you can apply for a trademark, even if you're not yet, even if you haven't made $1 yet. So that's something to keep in mind. But yeah, just to close, and thank you again for your time today. I think trademarks are, it is an important legal decision in terms of sometimes avoiding worst case scenarios of worrying, will I get a cease and desist letter? And by applying for a trademark, and more importantly, registering for a trademark, it does give you peace of mind in that regard, which I think a lot of small business owners look for. But it's also a business decision. So, maybe McDonald's can apply for 15 to 20 trademarks, and they have a trademarks team. But for most businesses, they might just apply for 1 trademark, maybe 2. But it gets to a point where you have to look at the, the cost benefit analysis of how much do I like this trademark? Am I going to, want to pay for the cost of registration? And more importantly, also pay for the cost of enforcing it. So once you have that trademark, you want to enforce your rights against others if you see that others are infringing. And then it's also a personal decision. Like I said, do you really love this trademark? Or is it something that you think you might switch to a new name in a couple of months? So to conclude, I want to give kind of the basics of some of the main considerations of trademarks. And then when people are ready to learn more, even if they're just curious about learning more of the basics and 101, this is a really helpful resource. And the goal is to get kind of the experience of someone that used to work there, and my subject matter knowledge from my years of working there, and hopefully explained in a way that's pretty, easy to understand. So I can stop sharing this, but I wasn't sure. I know I threw out a lot of information there, but if anyone has questions, or you can always email after, and we can answer your questions at support@mytrademarked.com. And Jim, do you have a question?
Oh, hi, James. Yeah, I had actually a hypothetical question, and then I wanted to tell you, get your opinion on this actual case that was about trademark infringement. Let's say Janice and I have a veteran that's getting out of the service, which is typically who we work with. And let's say they got their legal birth name was Thomas Brady. Okay. And they go by Tom Brady. Okay. All his life, he's gone by Tom Brady. And he just happens to love football and sports. And so he decides to open up Tom Brady's sports bar and grill in Panama City Beach. Okay.
Yep.
That looking for trouble, probably, from a legal standpoint, from I'm assuming maybe famous celebrities and all that trademark their names or whatever. So.
Yeah, that's a really interesting question. And I don't know if the PTO has had that come up before, of someone who themselves has that same identical name. But to give you, so Tom Brady has gotten into trademark issues before. He registered, I believe it was Tom Seaver, for that trademark, or what was the nickname that he was called? It was for a baseball player as well. And it got rejected by the Patent and Trademark Office because it was another famous athlete. And with that, you have to sign a statement. If it's a known person or a known commodity in that field, you have to sign what's called a consent statement. And it's basically saying, I am Tom Brady, and I authorize, my likeness and name for this with these goods and services. So in that case, it was actually Tom Brady trying to get another famous person's trademark, and it immediately got rejected. So it's very difficult to overcome. I think that's a novel situation that you came up with, in the sense of, if it is your name, I think there could be an argument that you could still register it. In practicality, though, if it is a known commodity, they probably have already registered it. So you'll get refusal based on that it's too similar. It's a Section 2D refusal. So, but in the rare chance that, a famous person hasn't registered it and you do have their name and likeness, I think you could potentially be able to register it. It's just, you can't take the goodwill of that person. So if it's Tom Brady and you're opening up a football shop, you're trying to kind of confuse customers in that case. But if it's, Tom Brady's boat, whatever, something not related to football, there'd be a stronger argument to granting that trademark. But yeah, for most case, if you're going to go, registering for Kim Kardashian or anyone who's famous, it's the consent statement that acts as the barrier.
Okay. And then to your very good point about the phonetically similar, there was a real case. This was like 25 years ago in the St. Louis area. I used to be a banker years ago up there. It was all over the paper. Back when Charlie's Angels, the TV show, was real famous, Farrah Fawcett, remember her? She was one of the stars, right?
Yep.
And she spelled her name, I think it's Farrah and then Fawcett, Farrah Fawcett. Well, there was this local plumbing supply wholesaler in the St. Louis area that, when that show was real popular, like in the late 70s, 80s, they started running this big ad in the local newspaper saying 20% off all of our Ferris faucets. And spelled it Ferris like iron, and then faucet like a water faucet. And I guess the Farrah Fawcett organization, for the movie star, they sued, saying that and then the plumbing supply company, their lawyers argued, no, Ferris with the iron spelling, that's common in the plumbing industry, and so probably is a faucet. I think it went up to like 3 levels of court over 2 years, and I think Farrah Fawcett did win, and they had to stop advertising that. So I guess you got to be careful that you're not trying to play on somebody's phonetic name, right? So,
That's interesting. You bring up a good point too of if you can argue that it's a parody, you have a stronger likelihood that the PTO will grant it. Because there's also considerations of, free speech and can you make fun of things, and trademarks. The goal of trademarks isn't to undercut those broader protections. So to give you an example of that, I think it's in the Supreme Court of someone wanted to register with making fun of Trump. It was called like Trump's little hands or something in that regard. And it got rejected by the PTO, but the Ninth Circuit allowed it. So now it's kind of in limbo of whether it'll go to the Supreme Court, but they allowed it because they were saying, even though that expression identifies a person and normally you would then need Trump's permission, or it would have to be Trump applying himself. They argued it's a parody. So in that case, the Ninth Circuit did agree with them. I don't know what will happen eventually, but that's something to keep in mind of, if you can show that it's funny or a parody of something, then you're no longer talking about something as like a source identifier confusion. So at that level, it's really kind of parody arguments is going to be your main, at least legal basis.
okay. And then last but not least, if Janice and I or any of the people from our office have a veteran that, they did the research, as far as, trademarks and all that, but they think that there might be a good case for their business to have one. If we send them your way for initial counsel, do you have like a certain fee for like an initial counsel or?
Yes, it would definitely, I don't off the top of my mind, but that we can definitely arrange for that as well, like a good discount.
Okay.
But yeah, for the most part though, the goal of the education is you really should be able to do it by yourself, but I understand there's always questions that do come up.
Sure.
And one of the best part, a comprehensive analysis of similar trademarks is, a lot of people do sometimes want that just to have that peace of mind before they even apply if it's going to be rejected. Because most rejections, most requirements, you can overcome them with the exception of the Section 2D likelihood of confusion and among a few other rejections, but those are the hardest to overcome. And a lot of times that's when people have to then do consent agreements or kind of, buy off the other company to allow them to also use it. But generally the 2D is going to be the hardest one to out argue at the PTO.
Okay, great. Well, hey, I really enjoyed it. Thank you so much.
Oh, thank you. Thank you for coming.
Okay.
Yeah, thanks. I've got a couple of questions too. It was easy to see how you did a search for a word or a phrase, but how would you search a design? Like if, just for example, the Nike swoosh symbol, would I type in swoosh or how would you look for that?
Question. So before I even answer that, one thing to keep in mind is that it's a lot harder to get a Section 2D refusal for a design. So it has to really be identical. And that's one thing I learned from working there was, I think I only did 2 design failures and I probably reviewed like 5,000 applications. That it really almost has to be like this blatant, they're so similar. But it's a little bit trickier and we do have videos for it, but basically the PTO gives design codes that you would have to search. So let's say the trademark had a lot of, dogs in it, or if it had 3 dogs in it, you can search this design code manual and it'll show you which design codes have the 3 dogs. And it gets a little bit more complicated than the other one because you want to then combine it with other design codes in this. So if you only had 3 dogs, maybe that's the only design code you search. But if there's also stars, for instance, you would want to search dogs and stars. So you basically have to find this design code at the PTO website, find whatever design elements fit within that code, and then search it that way. And one thing to keep in mind is you're going to get so many more results. So there's a video that talks about this, but there's a way to search through it that you then, just visually see it. So you can kind of go through it very quickly. But something to keep in mind is it's a much higher standard for them to find it to be confusingly similar. So if, that it's a harder process, but the odds of it being rejected are smaller.
So it sounds like that's something that you could probably do on your own and take that chance. If you only saw 2 or 3 out of 5,000 that got
That's a
rejected,
great
that's
point.
pretty good
Yeah.
odds.
Yeah.
We also
agree.
had a question that came up. It said, does the PTO database reveal status of processing or awaiting along with the evolution of the statuses? And that was another question I kind of had, like, if I wanted to use something, say I'm not in business like you were talking about, but I have applied for a patent, would there be a way that, I'm sorry, a trademark, because I'm used to seeing the words patent pending. Is there something like trademark pending or something?
Sort of. So when well, basically at that website where we search for similar trademarks, I should have done a better job of showing in one of the columns where it said dead. Other columns will have a registration number on it, so you know those are actually active or not. They're already registered. So it's either going to be dead, or you see a registration number, or it's blank. And if it's blank, it means it's under review, so it's pending. And basically, if you click on it, you have to do a little bit more investigation. But if you click on that file, you'll see where they are at in the process. And you can also, because everything is public information. So if you do click on that, you'll even be able to see what if the PTO gave an office action or, where they're currently at in terms of their status. So yeah, it's either going to be dead or registered, or, actually a good amount, especially now with their delay, a lot are going to be blank, which just means pending. And that's something I should also have mentioned, that because it is public, when you give your email to the PTO, that's something to keep in mind, that you will be getting a lot of spam emails and solicitations. And we've had issues with a company in Pakistan that's been targeting people and kind of fishing for money. So, you might want to consider using an email address that you don't necessarily use on a daily basis, because you will be getting lots of
great
emails.
tip.
Yeah, because of
We
that.
tell new business owners the same thing when they register their business with the Secretary of State. The same thing happens too.
Yes.
I guess one last question we have here is, do you have, or is there another search? Do we have to search any other databases besides the PTO if we want to register a trademark, or is that it?
So for most people, at the PTO, I'm only searching the federal database. So what you get in terms of your results from using that search is going to be the same thing that I review. I'm not going to Google. I'm not trying to see if there's other trademarks in business. But in actuality, with your business, even if you have a federally registered trademark, there could be an instance like that example with Baltimore, that maybe there's this weird example where someone was using a trademark in one local area and has certain small rights to it before you started using it. So they would have some rights in that small local area, even with their registered federal trademark. But in terms of like when you're thinking of that two-part test, you're only looking at what's coming up from those results. And it's not Google, it's not looking at state registries, it's just that federal database.
Okay, very good. Thank you.
Yeah.
Well, I appreciate this. You've certainly given us a lot more knowledge than we had at the beginning.
Oh, good.
And it's wonderful. And I'm glad that we've recorded it, because we wanted to share it with others who wanted to be here and could not be. So thank you very much. And thank you to the attendees. And we wish everybody a wonderful National Veterans Small Business Week.
Yes.
Thank you so much.
Again.